Yes, the other thing was even the stakeholders that were reached for purposes of public participation, handpicked, right? I remember one particular day, somebody was been religiously following this process. So I saw, it's I think it was a Monday morning. I checked the paper. I see the call for public participation. It's been posted at. So it's in the paper. So of course, whatever time the paper starts circulating, but the time I'm looking at it at my desk, it's a few minutes past 8. The thing starts in KICC at 9 a.m.
Yet I'm already in the office.
Yes, public participation. And I'm not saying I had to be consulted, because one of the findings that the court entered was that just because you made a contribution and it wasn't taken into consideration does not mean public participation did not take place. Kenya does not have a comprehensive regulatory framework on public participation, and maybe that's a point where we are failing.
An estimated 1.1 million Kenyans fall into poverty each year, and that's because of healthcare costs. Would SHA, SHIF, UHC change that, or is there more? Or perhaps, what's the difference between a pharmacy with a Blue Cross and a Green Cross? What about cancer and the rising incidence amongst the youth? Is it just lifestyle changes, or is there more?
Women's health, men's health, your children's health, the economy, this and more awaits you on season 2 of Kenya's favorite health podcast.
My name is Dr. Diana Wangari-Gitau, and welcome to season 2 of the One Health Lens podcast.
Hello, welcome to the One Health Lens podcast, where we have conversations around health and related topics, making them simple and easy for you to understand. I'm your host, Dr. Diana Wangari-Gitau.
And I am Dr. Simon Moshara Kigondu.
Today we're having, I would say it's a learning session, right? Because in studio with us, we have an important guest here to walk us through. On one hand, we had 4 healthcare acts: digital health, social health, primary healthcare. And we were in the process of implementation. Next thing we know, 3 of those acts have been declared unconstitutional, right? There's a petition somewhere. A lot is happening on the legal side. And that's what we're trying to learn and understand today. So I'll let the guest introduce herself and we'll get going. Nyambura? Yes, you can introduce yourself.
Hello, Dr. Wangari and Dr. Simon. My name is Margaret Nyambura. I am an advocate of the High Court. My specialty is health. So every time someone asks me, what do you mean you're a health lawyer? I mean everybody gets to choose what to specialize in, and for me it's health. So I am a program coordinator at the Kenya Legal and Ethical Issues Network on HIV and AIDS. In short, that's KLEAN. I'm happy to be here.
Perfect. Let's start from the beginning, right? Everyone is aware we had 4 acts, right? We had primary healthcare, we had digital health, we had social health insurance act. Was it a social health insurance act? And facility improvement act, right? There was, of course, a lot of focus around social health, right? But in totality, we needed all 4 acts to get going, right? And there were different parallel efforts ongoing, right? Then the next thing we hear, right, and I'll take it from a very layman's perspective, is there was a petition in court. And this is not the petition that was in November 2023. It is in 2024. There was a petition in court. Then there was some judgment, right? Maybe walk us through what has happened in the past just 2 months. What has happened?
Okay, so thanks for that. So just a small clarification before I take us back to 2023. It is the same petition.
Okay.
Yes. So so maybe just for some purposes of context, what's the general feeling of the public on changing from NHIF to a social health insurance fund? what's word on the street? What are the doctors saying? What are the people who you sit in church with saying? What are your relatives saying? Do people think the process has been clear?
No.
Do people understand what's happening?
No.
Maybe that's why we have the confusion. So this means that one, there was good reason for somebody to go to the High Court, which is the court where we go to seek interpretation of the Constitution on issues of the Bill of Rights. So in Kenya, the right to the highest attainable standard of healthcare, including medical services, including reproductive healthcare, is a constitutional right under Article 43.
Okay.
Now, having said that, I also need to mention that what we usually use is what we call the rights-based approach, so that on one end we have got the government, both levels of government, national and county governments. Those are the duty bearers, which means by dint of occupying those offices, then they are responsible for the delivery of the health service. And then we have got the rights holders, which is me, you, and Dr. Kigondu, and anyone else we might come across outside this studio. So now, let's not forget that health is a political good. I keep saying this all the time because why are we moving from NHIF to SHIF? Why? Roughly, I think just a little bit over a year in his time in office, President William Ruto did a complete overhaul of the social health insurance sector. So maybe when people were organizing how to get into government for this, what we have, the team we have in government right now, maybe the coalition sat down, maybe it was in the manifesto, maybe it was a bargaining chip to get into power. I mean, the same has happened in South Africa. President Cyril Ramaphosa was elected back into office days after he passed the National Health Insurance bill into law, which is also supposed to deliver universal health coverage. Education and health are socioeconomic rights which are so key to the quality of life that people live that we cannot gamble around them. So on one hand, we have got the issue, the fact that health is a political good. So you make the declaration, you make the promise, we are going to make things better. Everybody will simply have a card and go to hospital and you get the service. Now saying that is one thing and delivering it is another. So first you need to lay the groundwork. The groundwork usually is a regulatory framework. So here comes President Ruto with his team of 4 acts: the Facilities Improvement Bill, the Primary Healthcare Bill, the Digital Health Act, and the Social Health Insurance Act, right? So now with the setting we have right now of just the petition and what took place in court, so we have something we call public interest litigation. Maybe a quick 101 on what happens in court when you hear their cases. What's the difference between a petition, a civil case, a criminal case? If there is an issue of public concern, the Constitution guarantees any person the standing, well, we call it locus standi, but in simple English, that's just the standing, to go and ask or seek for interpretation from the High Court. So this is what a team of people, and the petitioner under petition E473 was a gentleman called Joseph Aura. So Joseph Aura had a team of legal experts, and he quoted some respondents, and Dr. Simon
you are part of that team.
Actually, he was an interested party, not him, but the
Kenya Medical
team. Yes.
Association. Okay.
So when you're going to court and you're asking for something, you have got to be very specific with what you ask for, especially when it is based on the Constitution. If you're claiming violation, you have to specifically state this contravenes Article this, and therefore it is a violation of my right under Article this.
Okay.
So one of the things that was put forward was that certain sections of these acts were unconstitutional because they offend some sections of the Constitution.
Okay.
So when you go to court and you're asking for something, that is what you get. What you don't ask for, you don't get. It's the same as what Christians believe in. You get what you ask for. What you don't ask for, you don't get. But there's usually a smaller, or rather a larger window. Let me call it a larger window because it is large. The High Court has got the jurisdiction. The jurisdiction is the capacity, or rather the the capacity to, yes, actually, capacity is the best word to use. They are the proper place to go to. That's the address to knock on when there's a violation, and therefore they need to have a response, or they need to have a remedy. One of the remedies that is usually available is what we call a conservatory order.
Okay.
So I don't know whether we've heard of the word injunction before. So if I was going to court to say Dr. Kigondu hit my car, then that would be a civil matter, right? So the kind of remedies you get in civil claims and in criminal claims are different from the ones you get in constitutional claims, which are constitutional petitions. So these we call petitions, we don't call them claims. So the conservatory order is similar to what in the ambit of public law. By public law, I mean issues to do with government administration, constitutional rights. That is what you would get, a conservatory order. As an interim remedy. So when the petition was filed in December and we went for Christmas holidays, I think it was, sometimes in November. Yeah. And then, so what we usually do sometimes is you seek an interim relief pending the determination of the whole shebang, the whole petition, right? Okay. So the interim relief that was sought was granted, which was a conservatory order, trying to stop the continuation or any continued implementation of these three bills, because for one reason or another, they were found to be unconstitutional, whether because of the procedure that was followed in arriving at the acts as we have them, or even the substance. So, for instance, sections 26 and sections 27 of the Social Health Insurance Act, right? So we went to court. So you term as respondents the people who are supposed to respond to the questions, just from the word respond, to the questions which you've put to the court. Because one, according to Schedule 4 of the Constitution of Kenya, the Ministry of Health is the relevant body for policy making as far as the health function is concerned. It's shared together with the county governments, the Council of Governors, but the proper place for policy making is the Ministry of Health, right? So Ministry of Health was quoted as a respondent, so was the Council of Governors, so was the Commission on Revenue Allocation, so was the Attorney General because of both houses of Parliament, so was the Senate, so was the National Assembly because they are the ones who have the legislative function with them. So now, after the petition was presented to court, we had a little bit of some procedural issues. So, for instance, the question of social health insurance is such a key issue. It is so central to the lives of people that the Chief Justice gave a directive that it should be placed before a 3-judge bench for determination. Okay. Now, do you remember the conservatory orders which we got to stop any further implementation? Yes. When the conservatory orders were given, the team that was representing the Ministry of Health, the National Assembly, the Senate, went to appeal that decision in the Court of Appeal. Because in the hierarchy of courts, when you're disgruntled by a decision of a lower court, you can always go to the higher one, with the apex being the Supreme Court, of course. Okay. So the question of whether the conservatory orders should have been given, the effect of which was the continued implementation of the three acts, the Social Health Insurance Act, the Digital Health Act, and the Primary Healthcare Act. The question was put to the Court of Appeal. So this is the reason why we had a decision out of the Court of Appeal even before the High Court pronounced itself on more substantive issues. Okay. What do I mean by substantive? The questions of, is it okay for us to peg benefit on contribution? A health economist will tell you that from a point of analysis, that's the only way to achieve universal health coverage in Kenya, given the history on how unsustainable it has been and how fragmented our schemes have been, right? So now the High Court gives conservatory orders. Disgruntled parties go to the Court of Appeal. The Court of Appeal therefore says that these conservatory orders are lifted. So what happens? Ministry of Health is given permission to continue laying the groundwork for the three laws. So at the point at which now we were receiving the judgment from the High Court on the substantive questions, we already had a digital health agency that had already been formed. We already had *147# being rolled out as the USSD code to run for purposes of registration for SHIF. We already had primary health care, community health workers and promoters and volunteers, all of them, the whole chain, they were already being disseminated by the Ministry of Health, right? So work continued, yet we still had not yet heard from the High Court on whether we are going to start contributing, and whether as a person who is not a fully paid up contributor, then we can receive any services. All this time, NHIF is still in place.
Yes.
So what do we have in the interim? We have got a transitional body, right? It is being headed. It has, I think it's an 11-member committee.
Yes.
And it's supposed to hand over everything from NHIF to Social Health Authority. The question of whether 1 year is enough is a question that we can have that conversation for long, but we will all agree that a year is not enough. I mean, if I'm just to digress a bit, South Africa is going through the same process, a similar one to what we have, trying to actualize universal health coverage, and they have got a two-phased approach, and it is spanning between 2023 to 2028 with two different phases. First, laying the groundwork, bring together the fund, and then now after that source for funding, and then now operationalize the fund. This is not something we could do in 1 year. The court actually notes this, that the activity was done in such a rushed way. It was so rushed, so unprocedural, because like we are going to see in a few minutes, all the processes that have been laid down to be followed by the two houses of parliament were not followed. And this is the reason why it fails to meet the constitutional standard, and for that reason a finding of unconstitutionality was entered by the court.
Okay, so what informed this? Because you've given us the context, it turns out it's the same one. So then what did the High Court then state? Because then there's the element of, yes, unconstitutional, right? There's an element of the process wasn't followed somewhere in between National Assembly, Senate, right? So what did they find, right? Maybe you can break it down 1, 2, 3, 4. What did they find?
Okay, so of the 6 questions that were distilled for determination by the 3-judge bench of the High Court, I think 3 or 4 would be relevant for this conversation. Okay. The first one was whether or not the procedure followed the national principles and values of, national values and principles. Participation of the public, or what we call in common parlance public participation, is a key national value.
Yes.
Its effect cannot be downplayed. This court found that public participation is a continuum. There is education of the public. Sensitization is the word that they use. And the sensitization is aimed towards creating public awareness so that the people who are now aware of what you're trying to do can participate in decision
from an
making
informed
with you.
point.
Yes. So that the decision making is going to be in a partner. We partner with the public to make the decision on what is going to govern them.
Yes.
And this is the finding. This is the finding of the court, that the petition did not meet the established standards according to a previous Supreme Court finding on what public participation should look like. I say this for this reason. The Houses of Parliament have got their own version of what to do so that they can be said to have adhered to public participation. So both Houses of Parliament have got a health committee. The one in the National Assembly is headed by Dr. Pukose, and the one in the Senate by Senator Amanda Gore. Both of them are usually the ones that are tasked with conducting public participation for bills that are relevant to their function. In this case, all the bills were relevant to both functions. Now, one of the processes which was flouted by both Houses of Parliament is the process of, so we have got a bill. The bill usually has got a section at the end that is called a memorandum of objectives or something like that, right? And now, at that point, you need to declare whether the bill is a money bill. There is a consequence of finding a bill to be a money bill. There is also a consequence of finding a bill to be a bill that affects the counties, because that then means it needs to have a day in Senate. Now, there needs to be a concurrence. If you find that a bill is a bill touching on counties in any way, there needs to be a concurrence between the Speaker of the National Assembly and the Speaker of the Senate as to which house is going to deliberate on the bill. Now, for these bills, for most of them, actually, I think for the Social Health Insurance Act and the Primary Healthcare Act, I'm supposed to do a letter. So if the bill rises from the National Assembly, the Speaker does a correspondence to the Speaker of the Senate and asks them to confirm that this touches on counties. Now, no sooner has one of
National
the
Assembly,
Speaker written to the Senate, then the National Assembly already starts deliberating on the bill, even before the Speaker of the Senate responds, confirming, yes. And the reason they give, for instance, the National Assembly, what the National Assembly said for assuming that, we already saw in the Memoranda of Objectives that it already says that it is a bill touching on counties. So there was no need for us to wait for correspondence from the Senate. So we went ahead and started deliberating the bill. That's underway. And at the same time, the Ministry of Health is in Mombasa. Coordinating public participation efforts with who? With the Ministry of Health itself, some stakeholders. Dr. Kigondu is laughing. I don't know whether he was in Mombasa with the team. Maybe he'll tell us. So one, can you see this process? So
too many things. We're not being systematic about it. Yet it's something that's so important and critical. And being in a country where healthcare is devolved, that means we fundamentally need county to be on board. There's need for that coordination. But things are happening. There's a rush here. There's a rush. National Assembly has passed this bill. The Senate, we're not even waiting for them. On the implementation side, we have already called some stakeholders. Yet this public participation and stakeholders should be inclusive, yet people are not even aware or understanding. So things are happening on a very critical public good function, right? Yes, I can see.
So now, when you have a look at the replying affidavit, a replying affidavit is the document you do in response to a petition. The one that was done by, what's the name? Council of Governors. They say they have got no problem with the bills, but they take particular offense with the process of public participation, especially when it comes to the Primary Healthcare Act. Remember, under Schedule 4 of the Constitution, primary healthcare function sits squarely within the realm of counties. Yet, public participation, or rather participation of the Council of Governors, or rather all the counties, was kept at a minimal. So even the selection of who are the stakeholders that were engaged is also a question, is also an issue that the court took issue with in arriving at the finding that there was no public participation. The amount of time that was given, oh my goodness, Dr. Wangare, there is a particular act for which
serious things.
Only 3 business days were given. And these are bills which raise such technical issues. So for instance, the facilities improvement bill. Even now that one was not even part of the petition, but have a look at the digital healthcare bill.
Act.
So the bill, and then it becomes an act. Such technical questions that I'm given 3 business days. So this is now
leave alone not even Nyambura, the expert who was
leave alone Nyambura, who probably this sits on what would be her day-to-day 8 to 5. Now let's find somebody. Let's not even look for the man on the street. Let's even just find a banker. So in three business, they probably planned their week on Sunday. You give them 3 business days to go over such a bill. There's somebody who would probably, given some time, would try to understand. Maybe if they are informed they're informed of how ICT systems work. But you give them 3 business days, and then even court also took issue with how small the print was in the publication. You
could barely read the fine print, as they say. It's like going to a bank and taking a loan. They give you that extra document, terms and conditions, and then you're signing. And then eventually they point it out. I see what you mean. I mean, so there's even an element of just the participation element, right? Because I'm imagining, let's look at our population, right? Because I remember it being on print and advertisement at a certain point, right? I remember it was like this week, then the next week we need to submit, right? So I remember professional associations, of course, are scrambling to get things in order. But in my mind, I had the thought that the person who can't perhaps, forget even stakeholders, who can't afford a newspaper, right? Someone who, first it was in English Swahili, the person who perhaps won't have access to internet. Then the next day you hear there's a team that has come to get your your opinion around something, right? I mean, my thoughts at that point was either the organization on the ground, we are not aware, right? So we are not aware of it, that then they know what they're doing and people will be able to respond accordingly. But from what I'm hearing from you, it was found that the timing, all the way from legislation, all the way down to community, wasn't even something that was feasible, but yet we were informed that it was done, and it was done in the right process, right?
Yes. So I just like to say 3 things about that. The attempt that was made at reaching the man, so let's say the person living in Lodwar.
Yes.
So when you also look at the replying affidavit done by the National Assembly, they claim that there was an activity geared towards public participation on the 3 bills that took place in Lodwar. Lodwar is in Turkana County. A review of the Hansard is the record of Parliament, reveals that not only was that a lie, there is no record. You know, I'm sorry, we can laugh because we can cry, but it's sad. It's sad because you are going to charge, or rather levy 2.75% of this person's income. You only publish the notice in newspapers of wide circulation. You put it on the website. I mean, fine. Mobile phone penetration in Kenya is at probably over 90%. Yes. But what are the chances that I'm going to land on this and respond in a meaningful way, qualitative and quantitative, in time for my contribution to make sense in the larger scheme of things? So that's one. So even the effort that was attempted was inadequate. Yes. The second,
go ahead. The second.
So the other thing was even the stakeholders that were reached for purposes of public participation, handpicked, right? I remember one particular day, somebody was been religiously following this process. So I saw, it's I think it was a Monday morning. I checked the paper. I see the call for public participation. It's been posted at, so it's in the paper. So of course, whatever time the paper starts circulating, but the time I'm looking at it at my desk, it's a few minutes past 8. The thing starts in KICC at 9 a.m.
Yet I'm already in the office.
Yes, public participation. And I'm not saying I had to be consulted, because one of the findings that the court entered was that just because you made a contribution and it wasn't taken into consideration does not mean public participation did not take place. But can you look at that instance that you're asking for public participation in a newspaper of wide circulation at 8 a.m. People sit down at 9 a.m. of the same day. Even if I'm in Nairobi and I'm in a position to
get to KICC,
right? That's also
not feasible.
So the court gave a whole it was like a 8-step guideline on what public participation should look like, and this is what we are hoping now that Parliament was told to do sensitization. They are going to make an attempt. Now let me just make one note at that point. Kenya does not have a comprehensive regulatory framework on public participation, and maybe that's a point where we are failing. We need one. I keep saying this every time I get a chance to. Council of Governors have got one because they passed one for purposes of use by the county governments. Now that one we cannot say it's binding on all public officers. There's also a draft policy since 2018, but it still has the large watermark draft up to today. There have been 2 attempts at introducing a bill on the floor of Parliament. I think now we have got the 3rd one. And for lack of a better word, even the most recent attempt is a very sorry one. Because one, bills, a legislation has got to have certain sections. And I just skimmed through the most recent attempt, and I'm thinking somebody who sits in government needs to intentionally introduce a bill that is going to make their work easy. Otherwise, there are going to be petitions flying left, right, center in their faces. You think we don't want development, but participation of the public is a national value. We are going to keep at this until we get to a point where we can have public participation. Let's have the framework and then we course correct, right? Let's set up coordinators, because the draft policy at least mentions some coordinators in several functions. Because right now when you are speaking, the person we would look to for purposes of public participation for a health function would be the minister. The cabinet secretary. doctor, whoever she is a very busy person. She has got to delegate that to someone. A framework has got to be created for that, right? So I think that's what I would say on the process of passing the acts and some of the reasons why they were found to be wanting and therefore unconstitutional. Now we can move into the substantive bit.
Yeah.
Thank you very much, Wangari, for having Nyambura. And I think we really, I've been looking for someone like her for a long time. And speaking from a professional association point of view, and we can say we are organized, and we really felt pressure and the timing, and we actually raised some of these issues, and it was obvious that the team, they had good intention. They were really rushing the process, and some of pressure. The things that they were under pressure, I suppose, I don't know, but the process was rushed, and some of the issues that we brought up, of course, we had to put in something as professional associations, and I think from reading from what she has said,
the nuances.
I think we have some time to go before operationalization of some of the bills that are got. But maybe as a parting shot, maybe what she needs to tell us is following the court pronunciation of itself. What timelines are we seeing? Because even as I'm speaking, I'm paying for my mother, NHIF still. Then we hear it's due again. We don't know for how long do we pay. From the legal point of view, and at least the legalese of it is objective, as opposed to our subjective views. We have many, which we can't say here. What will be these timelines? How fast do you think the framework will be made for public participation? And
even before you answer that, because I think that in fact is the final point, right? What you've outlined so far is process. There was a process issue, right? And a big chunk of that was coordination between Senate, National Assembly, public participation processes and whatnot. A ministry. So there was a big, and you can attribute it to that rush. Because as you say, in South Africa, it's phased out, right? Because fundamentally, I think everyone does want to achieve some level of universal health coverage, right? People want, grandmother, mother, if you're sick back at home, you will get services when you need it without us having to fundraise for it, essentially, right? So the spirit of it, I don't think is what's been is the issue. It's how it was done, right? That became the issue. But then there's something interesting, because even the unconstitutional element is on the substance. So before you answer Kigondu's question on timeline, maybe very briefly tell us, what did they find on the substance of it? What was the big findings, high level? Yeah.
Okay. So once again, back to what you put before the court. What you ask for is what you get, if at all you're deserving. If you're not deserving, you don't get. The articles of the Constitution of Kenya that the 3 acts were allegedly in violation of were around linking contribution to access, to the issue of specific and unique identification for purposes of access to this public service. The other one was also being a fully paid up member, so that you can access the service. And I think the other one was the issue of not having an exemption for purposes of emergency healthcare. Now, I want us to remember that, I'm sorry, I'm about to vindicate lawyers. The practice of law is not usually a finding of what is true and what is a lie. When you go to court, it's usually weighing two conflicting issues alongside each other and checking on the weight of the evidence that has been presented before the adjudicator, who is the magistrate or the judge, which is the heavier. And then we go with that. That doesn't mean these other guys are lying. It just doesn't mean their case wasn't as strong as the other one. Or rather, their lawyer wasn't as good as the other in some instances, right? So, on one hand, we have got Article 43.1 that presents the issue of everybody having the right to access the highest attainable standard of health, including reproductive health care. Article 43.2, we have got no person is going to be denied emergency health care. So once you're having all these conversations around
you must be registered that you must be up to date so that you access services, automatically you're saying that we are going to deny you health care unless you pay up to date. And in essence, it defeats the purpose, because if I'm sick, I get into an emergency today, it's not about pain, it's not, I should have care, I should have access to those services.
Yes.
Yet in this Social Health Insurance Act and the rest, they are saying that you must first of all be registered, you must pay up, you must, then it becomes unconstitutional. So
the High Court, as it is defending the Constitution and also interpreting it at the same time, has got two children that are being presented before it, the right to the high sustainable standard of health in 43(1), and the right not to be denied emergency health care on the other hand. None is the favorite child. Both of them are children because they're both put out in Article 43 on the specific issue of the right to health. So in all our considerations, because we are trying to limit one right, or rather we are sacrificing one at the altar of the other. So what court said is that there was a mistake made by Parliament by not creating an exemption for all the circumstances of emergency health care. So whether you want to make a case for economics in delivery of health service, and therefore you want to link contribution to access, which by the way I have got a very problematic
we'll cover it the next time, but
very problematic take with, because I am a champion for equity, which is also a national value.
It is. I mean, if we were to even go down this road, we'll even talk about openness, right? Because this is public, right? And social justice, right? And yet we were claiming how, or rather, part of it was funding is going to be collected. It wasn't clear how it's going to be structured. We'll go into all those details, right?
Without talking about money,
yes,
there should have been an exemption given in every clause, or every clause when it was a bill, and now every section now that it's an act. There should have been an exemption given for all circumstances of emergency healthcare. So court said, take this back to Parliament, let them have in the exemption for all instances where there is emergency healthcare. So those are some of the substantive bits.
Okay. So it's High Court has given its judgment, take it back. They've been given, I think, 120 days to redeem themselves. Then the Attorney General Office gets 45 extra days, so we have 165 days to redeem ourselves, right? Is it, now to Kigondu's question, as part in short, is it attainable, right? Given the process needs to be followed, so that we're not going through this loop of they're trying to redeem themselves, then it becomes process wasn't followed, right? Is it attainable? 165 days, is it?
That's a very specific question, and as a lawyer, I'm bound by the words it depends. So I'm going to give you two scenarios. Sorry.
Yeah.
So whether we take 3 years or 4 years, we have to get these acts right. We have to, because we have to discharge social health insurance in Kenya, right? So so court could not pronounce itself and give an open window. They had to cap the days at a certain number. Otherwise, otherwise, what win would that be for the petitioner? You've not given me a timeline within which to supervise the implementation of the judgment. So what have you said? It will be open-ended. They gave the number of days. I, as Nyambura, would not understand why the days were given or what the consideration was for that, right? But everybody, even me when I was a pupil, if I go to court and I'm going to collect a judgment, a ruling for any reason, the most prudent thing is, after a ruling is adverse to you, you get up and you ask for stay. Everybody has got everybody needs to do that,
just in case I need more time.
Not even more time, because the curtains have closed, but this is for you to try and mitigate the consequences of what has just happened, because remember, both of us went in looking for a win, right? So the words of the council, if I'm right, were for any of the parties to appeal. Remember, there's a list of 12 respondents. All of them, the officers need to do something, right? So if any of the parties needs to appeal. Now, this is somebody who came to court probably having thought of what it would look like if the finding was adverse. But now they have to come back and look at the legislators whose function it is to discharge this duty or this function. First of all, by the time the judgment was being read, they were in recess. Sorry, members of parliament were in recess, right?
Yeah.
Members of parliament were in recess.
Yes.
So you come back and you look at the diary. We have got the ones which are usually permanently diarized, the breaks that they need to take.
Yes.
And then you have got their work, which is also cut out for them. Now you're trying to fit in this agenda back into the house business. And so they look at it, and they are saying, I don't know who, but they are saying that if you're to look at the kind of work that needs to happen and proper coordination with the Ministry of Health, it might probably take a year. It might probably take a year when you're taking into consideration
just to package it properly for presentation again.
Now, I don't know whether they're going to go back to court for this. I am yet to see, because this thing is evolving. It is still green. We wake up, we see a notice from the Social Health Authority saying that in the meantime, social health insurance still has to exist. So NHIF is still on, which by then would still have been on because the transition committee is on until November. But let me remind you, today is 2024. We passed the constitution, we promulgated the constitution in 2010. There are some functions which have still not yet been properly handed over. That's 14 years later, which means we are rushing the whole 1 year thing. We can have a longer period. The transition committee could get an extension. I don't know, Dr. Kigondu is smiling. Maybe he has some comments about that.
Those ones we won't ask him even right now.
But there is the issue of demoralization of the staff at NHIF, because now Dr. Kigondu just said he's paying for his mom, but his mom going to get immediate assistance. Is she going to get pre-qualification, but pre-authorization when she goes to hospital? You remember there is also a case before the Employment and Labor Relations Court on whether or not the health workforce is going to be carried on to the Social Health Authority. Now, can you imagine going to work every day and knowing that there is a timer on my being here? Right? So, of course, there's little we can do about that demoralization. People are complaining about it in the country, so maybe something needs to be done there. Just the other day, the Social Health Authority published the frequently asked questions in the dailies. I saw them, and it was also just an oops moment, because I happened to be in a household where one of the senior citizens reads a newspaper. And it was in the spread in the center, at the center page, and some questions were unanswered.
Nyambura, you need to come back so that we dissect one by one. Kigondo, I know you have pressing moments, but we don't have time.
Okay.
I know there's a lot, but
so sensitization has to take place. While Parliament is reviewing the acts and putting in the exemption for emergency healthcare, Ministry of Health has got to find a way to do the sensitization in such a way that the public is informed and is able to partner in decision making. At the same time, they need also to be making sure that the systems they've put in place are in congruence with the systems in health facilities all over the country. So much has to happen. So
I mean, the rush, I think in this show what we've been seeing is the spirit is something that we're supporting. It's the timeline that doesn't make sense, right? It doesn't make sense. And in everything in life, if you rush, you're bound to make mistakes. You're bound to overlook certain things, which perhaps wasn't your intention to overlook, but it happens, right? So I think, Nyambura, thank you. Thank you so much. You're coming again. We are going to be here dissecting one after the other, because as you're saying, things are evolving, right? And people essentially are asking, is this going to happen or not? There's conflicting messaging as well, but we'll take it a step at a time.
Okay.
Thank you so much for coming.
Thank you for having me, Dr. Wangari and Dr. Kigondu. When I come back, I hope I can speak about the disputes tribunal, because I happen to have sat in the previous year. So now we got a new council, and therefore we don't have our specific committees out yet. So I happen to sit in the previous medical legal committee at the Law Society of Kenya, and we haven't seen the rules that are supposed to govern the administration of law at the disputes tribunal, the specific one for the social health insurance. We haven't seen them. I think there's also a set of regulations which has not also been run by us as the legal specialists in the country. So let's break this down an episode after another.
Because
thanks for having me.
Absolutely. Thank you. Many gaps, eh? Thank you so much for joining the One Health Lands podcast. We'll see you next time.